When I say British system, you all must be aware that our laws are based on common law jurisdiction. Internationally, our laws have evolved as a common law jurisdiction. If you ask me how Indian laws have evolved, Indian laws have evolved based on various religious texts over a period of time. We may agree on that, we may not agree on that, that is different. But always the Indian system of law has evolved based on the religious text that was prevailing across the country, based on the culture. And this over a period of time, when the Britishers came to India, we have the East India Company. East India Company, even though had a commercial object, but they thought their commercial object can advance only if there is administration aspect also. So very important to note, wherever Britishers went and colonized, they just did not colonize the people based on their product. All that they did was, if they are able to administratively control, not only they can advance their commercial object, but also can transform the cultural aspect so that their commercial object goes on forever. So with this idea in mind, what the Britishers did was that through East India Company, they established the judiciary very strongly. If you see Madras High Court, Calcutta High Court, Mumbai High Court, all these are all courts which were established during the British time itself. Even the building that we are now we go to argue, they're all constructed by the Britishers. Little changes have happened in those buildings. Not only buildings, but also the laws and regulations. So when the Constitution of India came, doctrine of eclipse started operating. What is this doctrine of eclipse? You all know Baba Sahib B.R. Ambedkar, along with the Constituent Assembly members, drawn from various parts of India, came together, sat through, discussed, debated, argued for us. Whatever we have as a constitution today is binding India. And whenever people criticize constitution, or people actually comment about constitution, always they should revisit the Constituent Assembly debates. Our forefathers, or the founding fathers of the Constitution of India, did not bring every word in the Constitution of India was brought with a meaning. So today, being here in the 2024, when you criticize, comment, and talk about Constitution of India, understand the mind of the founding father. The primary role of the founding father was to bring a fabric to unite this nation. Whether it is a reservation policy or whether it is a criminal justice system, each article of the Constitution of India is crafted and they drafted. Both happened. Ambedkar wanted to bring all the articles only to ensure that the social fabric of the country remains intact. And when Constitution of India came in 1950, doctrine of eclipse operated. What is this doctrine of eclipse? This is very important to understand the new criminal law. I will get into the new criminal law shortly. First, let us understand how the Constitution of India works. You may be expert in various articles because you would be attending many classes and referring to Constitution in polity and every sphere of your preparation. But how it evolved over a period of time is very important to understand the framers of the institution. And as the Constitution of India came, doctrine of eclipse operated. Doctrine of eclipse. The doctrine of eclipse is a fundamental concept where there were a set of laws brought by the Britishers, which was prevailing in our country. Suddenly, new Constitution of India comes, replacing the Government of India Act. Before Constitution of India came, Britishers had Government of India Act, and all these constitutional matters had the base in the Government of India Act. Many of the articles in the present Constitution of India is also adopted from the Government of India Act. This was brought by the Britishers to administer us. So when Constitution of India came, doctrine of eclipse operated to an extent where The old laws which are in conflict with the Constitution of India were replaced or amended in line with Constitution of India. Two, those laws which are completely against Constitution of India were scrapped or repealed, I would say. So what prevailed after Constitution of India came in 1950 are those laws which were to an extent, I'm using the word called to an extent, relatable or constitutional, and which did not go through the judicial review. Post Constitution of India came, Constitution of India itself got amended in certain places to accommodate the needs of the country, and in certain places the question of law of the respective laws which are in conflict with the Constitution of India, the apex court or the Supreme Court or the high courts started interpreting, started coming out with the judgments to clarify on those laws. So from 1950 onwards, various amendment has happened. One thing that has happened is various so all those laws which are in conflict with the Constitution, many advocates and many public intellectuals started filing writ petition. You all know about the constitutional remedy. How do you get a constitutional remedy? We get a constitutional remedy through two routes. Very important as administrators and people who aim to be in the government, because most of the time, if you become a government official, I will come there to fight with you. Let's assume you are a police, you become a police officer, IPS officer, or you become a IAS officer, or even you become IFS, whatever government order, notification, or whatever you may bring, lawyers like us, who are part of the judiciary, will look into your notification, GO, and look at what is the case I can file, questioning from the perspective of Constitution. What rights are affected, what article is affected through that notification. You bring any notification, any form, I can question through Constitution. Ultimately, judiciary will decide. That's a different issue, but I can raise issue from many angles. If you bring a notification affecting a class of people, then I will question through Article 14. Then if you bring a special recruitment process in the government, then I'll question through Article 16. Beyond all these things, I'll question from the perspective of different articles, which can all notification will have to hit the ceiling of the Constitution. So knowing this evolution over a period of time, writ petition, filing a writ petition, and then coming out with the constitutional question, and certain times amendments are passed in the Constitution itself. Take for example, recently in 2017, before I come to criminal justice system change, I need to empower how the Constitution works, so that you will get to know what are the changes that is happening in future, what I will do against the administrator, or administrator has to be aware of. In the sense, when I say I, judiciary, because that is a relationship. The relationship between the administrator with the public is always questioned through judiciary. So considering that fact, you should know how later point of time this criminal justice system is going to go through the constitutional questions. So in 2017, one major constitutional amendment happened. That constitutional amendment is to enable GST in India. What is that constitutional amendment? Before GST came, respective state government had VAT, central government had the power to tax the services. State never had the power to tax the services, and sale was never the part of the taxing system of central government or the union government, as the case may be. So I have to have a shared power. To bring the shared power, what was amended was Constitution was amended. So only when the Constitution was amended, state got the power to tax the service, and union got the power to tax the sales. So considering this, the constitutional amendment was brought to bring the GST. So now you have two GST, CGST and SGST. Why am I giving this example to you? You cannot bring an act if it is unconstitutional. If it is unconstitutional. Why people fear majority government? Because when majority government comes and they occupy Lok Sabha and Rajya Sabha and 50% of the state assembly, I just need some answers from you people. What will happen? This question alone. In Lok Sabha, I am majority. In Rajya Sabha, I am majority. In state assemblies, I am majority. That is, I'm crossing 50%. Let's assume 50% of the states I occupy as one political party, for example. What will actually become a problem? What is it? Every single bill will be passed. Okay. It can impact the federal structure of India. Super. Then, come on. Whatever you know, answer. Now, it doesn't matter. What will happen? You think you are the prime minister. You got majority in Lok Sabha. You got majority in the Rajya Sabha. And 50% of the state assemblies are occupied by your own party. And you are the prime minister. From that perspective, you think and tell me. You might affect the Constitution of India, even the structure of the Constitution. Think about the days when we had the emergency. What was affected was not people. What was actually shaken was the Constitution. Then later point of time in the Keshavanandi Bharati versus state of Kerala. What was brought was the basic structure of the Constitution of India. And the person who argued was Nani Palkiwala. And where did we get the basic structure of Constitution of India from? It's a very interesting incident to note that Nani Palkiwala went to lunch and in the library he found Australian Constitution. From the Australian Constitution only we got the basic structure of India. Let's assume if Nani Palkiwala, of course arguments happened, but one single day how that was arrived was Nani Palkiwala went for a lunch and his friend brought Australian Constitution and said, "This, look at, there is some basic structure." And Nani Palkiwala immediately prepared a petition and argued on that matter, and that became a basic structure of India. What would have happened if Nani Palkiwala did not have a lunch on that day? So a good point to note here is we have come far. When there is a majority government, all that we fear is whichever party for that matter, they will advance their political ideology as part of the Constitution of India. It has happened in the past. It might happen in the future. But checks and balance always happens in the federal structure. And whatever may be the change, the first effect will be on the administrator. First effect will be on the administrator. So considering this fact, now India has new criminal justice system. So after independence, we are bringing a transformational reform on the acts which are criminal acts in the country. What has changed from July 1? The relationship of the citizen with the state. If somebody is going to ask you, because of new criminal law, what has happened from July 1, your single line answer should be the relationship of the citizen with the state has changed. How is this relationship affected? How is this relationship? Each and every citizen's rights are affected because of the criminal justice system. Let's assume how many of them want to become an IPS officer here? Good. How many of them wanted to become an IAS officer here? Okay. My dear friends, as you aim to become this any act, let's assume GST, it also has an impact on the citizen from the perspective of collection of tax. But criminal justice system has impact on rich and poor, irrespective of the fact, whatever may be their financial condition. Let's assume the first FIR in Delhi was not filed on a rich person under the new law. Under the new law on 1st July 2024, FIR was filed on a roadside vendor. Hello? Roadside vendor. It was not filed on a rich person. It was not filed on the so-called elites who are running businesses in the top commercial houses. It was on the roadside vendor. So what you should understand, it impacts each and every person in India. Now let us get into the new criminal laws. First issue that I'm going to discuss, issue by issue. Let's not get into the section because you are not aiming to be lawyers. Neither I want to burden you people with section numbers. Neither I would like to take you through section numbers and confuse you. All that I'm trying to do today is to bring an overview of transformation that has happened in the criminal justice system. If you ask me independently, do you support this criminal law? Answer is yes, because I'm making a fortune. Personally. If this new criminal law would not have come, I would not have met you. So I'm able to meet you. People are recognizing my lecture. That is fine. But actually it is affecting larger masses. First issue of the new criminal law, the name itself. Can you please pronounce the name? Bharatiya Nyaya Sanhita. One advocate called me. Very nice, humble person. And sir, the புது லாலாம் வந்திருக்கு. கொஞ்சம் ப்ரொனவுன்ஸ் பண்ணுங்க சார். அப்படின்னு கேட்டாரு. சார் இது சார் நீங்களே ஒரு படிங்கன்னு சொன்னேன் நான். இந்த லா இருக்குல்ல. அது நீங்களே படிங்க. அவர் ஒரு பிராக்டிஸ் பண்றாரு. எங்க பிராக்டிஸ் பண்றாருன்னா, I hope everybody understands Tamil. Everyone? No. Okay, but still I'll try to. There is more interesting conversation. He comes from Mofussil area. And then he calls me. Says, sir, I practice in Mofussil area. Look, you are in public. You need to question this, sir. I said, what? What is the problem? Sir, this act name itself is a problem, sir. Why act name is a problem? Why? Sir, it's in some language which I don't understand. Understand? He doesn't even know that it's in Hindi or Sanskrit. Leave alone, you would identify it as Hindi or Sanskrit. Okay. That too, in Tamil Nadu, somebody is practicing in Mofussil area. For him, sometimes he doesn't know the full form of IPC also. He will just say 420. 420 power. Suddenly somebody will say 420. 307 case pa. 307 of Indian Penal Code 1816. Solla kuda mattaru. It is so accommodated in the culture that section number means everything. 420. How do you know? Correct? So this is how the criminal system has been working. Suddenly you bring a transformation, not just in law, but in the name. Bharatiya Nyaya, or pronounce person one, or enna sonna Bharatiya Nyaya Sangeetha nu sonnaru. Ipo this difficulty, this may be a joke for all of you, or for me also, or for the people who are looking at it. But the larger impact of it, Constitution of India itself bars the law from any other language other than English language. This I myself didn't know until he asked me. Think about then what I should appreciate is those founding fathers of the Constitution who have accommodated even him. For him also the Constitution works. Under Article 348 of the Constitution of India, you must refer this today because you are all going to be the future administrators. It says very clearly the language of the law should be English language. Hello? It's English language, not English letter. My friends who understand Hindi and Sanskrit will come back and say, sir, Bharatiya, Bharatiya. Kandasamy is Tamil name. You put Kandasamy in English, that does not mean it's English language. It is English letter. Transliteration, it's not an English language. So, in Constitution of India, this matter was debated in the Constituent Assembly. So, what we have filed a petition in the Madras High Court. It's going to be heard shortly. Section Article 348 of the Constitution of India is very clear. Language to be used in Supreme Court and High Court, and the acts has to be in English language. You can refer right now. And unless there is a law passed to specifically say other than English language. So let's assume I want to bring a law other than the English language, then I have to pass a law in the parliament to say I'm going to bring law in language other than English, for which I have to pass a law in the parliament. I hope you can understand. That is a kind of importance founding fathers have given on language. When we brought Constitution of India, it is not the Britishers who brought the Constitution of India. It is our own representatives. It's our own people who represented different cultures and regions of this country who sat and discussed about it. So immediately what I did, I just knew 348 article. but I should know the history of 348 or not. So what I did, I went through the literatures which gave background to 348 article 348. The background of article 348 in the draft constitution was article 301F, not 301F of this constitution, but in the draft constitution. That draft constitution was brought by Mr. P.N. Rao. Subsequently, one day, Ambedkar comes as the chairman of the drafting committee, and Ambedkar actually he took the lead of agreeing everyone, trying to bring a kind of a consensus. It was a big role that he played. And because of that, Article 348 came. When we went and checked Article 301F, the initial draft had 2 languages. What would have been the language? Hello? Hindi? English. It is surprising to find neither both was there. Hindi was not there. Then what language would have been there? Sanskrit also was not there. What language would have been there? Why Urdu? Hindustani was there, which means Hindu, Hindi, and Urdu. Hindustani, the word used was Hindustani. Then people started debating. You must refer the Constitutional Assembly debate on 14 September 1949. Please take down this note, dates. 14 September 1949, 15 September 1949. All these dates, debates happened with respect to Article 348. Now Article 348, earlier 301F. Wherein they were very clear. They came to a conclusion. Day long they debated. What language? Please understand, India got divided because of language. Every state was divided because of linguistic reason. That you must be aware. So now, what language can be used in law is the particular question. It was concluded after the entire debate by the chairman of the drafting committee, Babasaheb B.R. Ambedkar, that it has to be in English. English language. The first fundamental issue of the 3 acts. What are the title? Now you started pronouncing as BNS, BNSS, BSA. Okay, whatever, BSA, SLR cycle, whatever. So fundamentally, name doesn't matter, but somewhere down the line, name has actually taken over the political system in this country. Naming, renaming, leave the party, that is different. But naming has become such fundamental issue today. I'm happy about many of the changes that are brought with respect to women and child in the present act. I'm not saying that there is no merit in this new act. But all that I'm saying is, the founding fathers were very clear why it should be in English language. Now you're breaking that vision of the founding father. There is a kind of constitutional question that has come up before the Constitutional Court in the Madras High Court itself. So we have also filed a petition in the Madras High Court through writ petition to question fundamentally with about the name of the new laws. Bharatiya Nyaya Sanhita 2023. Bharatiya Nagrik Suraksha Sanhita 2023. Then you have Sakshya Sanhita Abhiniyam. Okay, so you have these 3 names. We have questioned these 3 names because act itself cannot be in a language other than English, but you have named the act in Hindi without passing an act in the parliament. So this is a first constitutional question. Act cannot be in any language other than English language. That's what Article 348 says. If you are going to name any act in any language, not just Hindi or whatever, then you can have translation of the act, but the original act itself cannot be in another language other than English language. This is the first fundamental question, constitutional question, that has come up before the constitutional courts in the country. So we are waiting for the Madras High Court to decide the matter. The matter is before the court. and the case is listed on July 23rd. And some more petitions are being filed each and every day on this new law. Next important fundamental question, issue number 2. Is on 1st July 2024, new act came. Observe these questions. Let's assume you are IPS officer. You are the commissioner of the city. Imagine the situation. You have to file an FIR on that day. Crime happened before July 1, 2024. Understand the case study. Crime did not happen on July 1, but crime happened on June 30. Under which act you will book the crime? Why? Crime happened before the date. Why you will book under new IPC? Because you may not be aware of Article 20, but Article 20 is a very fundamental to the criminal justice system. Because under the new law, I'm getting into the advanced level of discussion. Please take this situation into your mind. On June 30, crime happened, but the crime got reported on July 1. Constitution says very clearly, on the date of crime, whatever law was there, that punishment should be imposed, or the criminal has to be brought under that punishment only, under that punishment system, the criminal system. If there is an enhanced punishment, under the new law, there is an enhanced punishment. If you are going to bring an enhanced punishment on the crime that was committed when the law was not effective, then it becomes unconstitutional. You may ask me, sir, what is this? Then now the next question I'll ask you, on July 1, 2024, whether the old act got repealed or it is still effective? Still effective? Are you sure? That means two criminal systems are prevailing now. Hello? You're able to understand? I'm bringing up issues before you. See, becoming an IPS officer is a matter of time. But thinking in that direction, you can think right now. You are the IPS officer, you are the police official today. On 1st July 2024, whether you have the power to file an FIR under the old law or the new law. Depends on. But on July 1st, 2024, there is no old law. In the law that is not effective on 1st July, how can you prosecute? How can you actually file a case on someone when the law itself is not effective? So this is another constitutional question that will hit the constitutional ceiling. Now, for lawyers, it has become third issue. I hope your thinking is now expanding. Today my role is to first expand your thinking on the new law. Then if I'm going to tell you what are the changes, then you're going to listen to me. Now I come here and then show some section changed. Then you'll only be noting down mechanically and then go back and scold me. என்னடா நடத்துனாரு ஒண்ணுமே புரியல, சும்மா ஏதோ செக்ஷன் நம்பர் வந்தாரு, இதுதான் வக்கீல்லாம் நடத்தக்கூடாது, எப்படி புரியும் நம்மளுக்கு அப்படின்னு. First I want to expand your thinking. Let me come to the next issue. I spoke about the police official. Let me come to the people who are practicing law like me. Tell me, from 1st July 2024, I have to carry criminal laws to the court. Criminal laws to the court. Which criminal law I should carry? Answer. Depends on the case. Good point. He's a prudent person. But still, I appear 10 cases in a day. Do you think I appear only one case? Whether it is possible or not, still we will appear. Sometimes there is a case which I don't even know which case. Before 5 minutes only, we'll prepare and go. That means I'm not just giving an example where each advocate appears for multiple cases in a day. Let's assume the cases which are framed on 1st July and you are applying for a bail. I have to carry new law. For those cases which are pending trial, I am placing a return of property for the search that has happened and seizure that has happened, which has happened before July 1. Which law I should take? So 2 sets of books I am carrying. 2 sets of old criminal law. How many years I should carry? You tell me, please. How many years should I carry? When will it get over? I have a case which I am appearing. FIR was filed in 1998, my dear friends. I was in the 5th standard or 6th standard. I don't know which class I was. That case, now I am appearing on a matter of a discharge and a quash of a charge. Still trial has not happened. So, now let's assume if this new law would have come in 1991, let's assume before the new law came, 1 day before, if the case is filed, until now I have to carry the old law. Yes or no? So the issue is multiple level. Issue is, so hope you are able to understand the issue in the first place. Criminal law system has changed. New laws have come. Every citizen is protected. How he is protected? How he is protected? Let us assume. Next issue. I have discussed how many issues as of now? 3 issues to expand your horizon of thinking on the new law. Because I am going to have one more lecture, and in that I am going to go in depth on the section number so that you understand. Now, on someone FIR is filed. It's a cognizable offense and non-bailable offense. We'll get into what is cognizable offense, non-bailable. There are broadly, please research and come back, because if I get into what is cognizable, what is bailable, then it will take time. I'm not here to teach law, but I'm here to come and enlighten about the new law. So that means you should basically understand certain terms. So go today and understand what is bailable, cognizance, non-cognizable offense, and bailable, non-bailable offense. Let's assume FIR is filed and person is arrested. Person is arrested. Tell me the sequence of event. You need not know the section numbers. So tell me a sequence of event. What happens when you file an FIR? Immediately will you produce? Before 24 hours or end of the 24 hours? Before. So it can be 23 hours, it can be 22 hours. It is not mandatory, it should be 24 hours. Answer yes or no. It is within 24 hours or at the end of the 24 hours. What happens if you produce him at the 25th hour? Hello? Tell very clearly, it is unconstitutional. Tell very clearly, loudly, unconstitutional. Constitution of India says 24 hours means 24 hours. So what does police officer do? I see many of them aspiring IPS officials. What does police officer do? They will arrest somebody, but they will not inform the arrest. 3 நாள் முன்னாடி அரெஸ்ட் பண்ணி வச்சிருப்பாங்க. ஆனா கோர்ட்ல காட்டும்போது ஹலோ இப்பதான் கரெக்டா 24 ஹவர்ஸ் காட்டுவாங்க. ஓகேவா? ஓகே, அதான் நடக்குது. அதை நாங்க கொஸ்டின் பண்றோம். சப்சிக்வெண்டா அந்த கேஸ் ஜெயிக்காம போறதுக்கு, உண்மையே அந்த கேஸ் இருந்தாலும் கிரைமே இருந்தாலும் ஜெயிக்காம போறதுக்கு போலீஸ் அபிஷியலே காரணமாயிடுறாங்க. கான்ஸ்டிடியூஷனலா பண்ணா அந்த கேஸ் ஜெயிக்க முடியும். இப்ப எங்களை மாதிரி இருக்கக்கூடிய அட்வொகேட்ஸ் என்ன பண்ணுவோம்? ப்ரொசீஜரா கொஸ்டின் பண்ணுவோம். நான் உண்மை தூத்துக்கே போல அந்த கேஸ்க்கு. அப்ப ப்ரொசீஜர் என்ன? Constitution of India says, Article 21 says, within 24 hours you have to produce him in the nearest magistrate. You cannot tell a reason that you will arrest him in Tirunelveli. The crime happened in Chennai. To bring him here, flight was not available, train is not available. Because of the 24 hours process, you have to produce him by the, think பண்ணுங்க, கான்ஸ்டிடியூஷன் கொண்டு வந்தவங்க எப்படிலாம் யோசிச்சிருக்காங்கன்னு, எப்படிலாம் தப்பிப்பாங்க, எப்படிலாம் பிரச்சனையாவும் நினைச்சதுல கொண்டு வந்திருக்காங்க. The greatness lies in foreseeing the problem. கரெக்டா? Greatness lies in futuristic. So என்ன பண்றாங்க? மெஜிஸ்ட்ரேட் பக்கத்துல இருக்கிற மெஜிஸ்ட்ரேட் கிட்ட ப்ரொடியூஸ் பண்ணணும். அதான் 24 ஹவர்ஸ். ஒருத்தர் அப்ஸ்காண்ட் ஆயிடுறாரு, சென்னையில கிரைம் பண்ணிட்டு திருநெல்வேலி அப்ஸ்காண்ட் ஆயிடுறாரு. உங்க பேர் சும்மா எக்ஸாம் சுமன் IPS. அவர் போய் என்ன பண்றாரு? அரெஸ்ட் பண்றாரு. அரெஸ்ட் பண்ண உடனே 24 ஹவர்ஸ் அங்கிருந்து கூட்டிட்டு டைம் ஆயிடும். அப்ப என்ன பண்ணுவாரு? அங்க பக்கத்துல இருக்கக்கூடிய, சாரி, பீப்புள் who don't know in Tamil, he will just produce him in the nearest magistrate, and magistrate will record that and then subsequently transfer him to the respective jurisdiction. This is the system. Now, after he gets arrested, what comes as a concept? What comes as a concept? He is arrested, you are taken him to magistrate. If it is bailable, magistrate might give bail, that is different. Most of the cases he will not give. Considering the fact if it is cognizable and non-bailable, definitely investigation has to go through. Custody has to be granted. Yes or no? There are two types of custody. There are two types of custody. One is police custody. Many of them will not even know the difference between judicial custody and police custody. Police custody means physically I'm with the police station. Judicial custody means police only arrested. In jail also police only is there, but he is under the custody of the court. You understood or not? You tell me which is better. Which is better? Suman IPS itself is saying, aspirant, IPS aspirant, judicial custody only is. Yeah, just kidding. I'm just giving an example. Of course, law works as per the situation, not as per the wish of Suman or Sathya Kumar. Yes or no? Suman is an IPS officer, Sathya Kumar is an advocate. What's the guarantee tomorrow Suman will arrest and I will not defend him? So it works as per constitution. Suman has to work as per constitution. Sathya has to argue as per constitution. There is no right and wrong. In law, there's nothing called right and wrong. Whether it is constitutional or unconstitutional, whether lawful or unlawful, finished. Don't expect a right and wrong in court. Whether it is constitutional, unconstitutional, lawful, unlawful. This should go into your mind. கரெக்டா தான் சார் பண்ண, நோ தப்பா தான் சார் பண்ண, நோ தப்பு ரைட் நீங்க நினைச்சுக்கிறீங்க. லாஃபுல்லா அன்லாஃபுல்லா, லாஃபுல்லா அன்லாஃபுல்லா. Now when custody is taken under the old law, without referring to the section number, understand the concept. I will come to the section later. It says 15 days police custody. How many days? 15 days. Immediately Suman will ask the court, when bail is not granted, immediately will ask what? Police custody கொடுங்கன்னு கேட்பாரு. கரெக்டா இல்லையா? எத்தனை நாள் கேட்பாரு? 15 நாள் ஒரேடியா at a stretch can he ask 15 days? Or can he ask 1 day, 2 day, 3 day, 4 day? It is his wish. But he cannot ask beyond 15 days. So here, the police custody, 60 days or 90 days as the case may be, within the judicial custody, within the custody, there are two parts. One is the judicial custody, another is police custody. Very interesting. Maximum time police can actually take him on custody within 60 days or 90 days as the case may be is 15 days only. They can either take 15 days at a stretch, or they can take 15 days in periodically within 60 days. There are many Supreme Court judgments wherein first 15 days, if police has not taken custody, whether they can be provided custody. Answer is yes. The Supreme Court have come back and said that 15 days period is within 60 days and they can be given police custody. Next comes, many of the law enforcement agencies are not police officers. Take example, Enforcement Directorate is not a police officer. It is not a station house. Now, whether the judicial custody is 15 days or more than 15 days, or 15 days has to be provided at a stretch, or if this 15 days cannot be taken, custody cannot be taken, whether that custody can be taken in 60 days or 90 days as the case may be. This is the confusion already prevailing in the old law. 60 days or 90 days, 15 days in police custody, 60 days on the total custody. And the 60 days to 15 days minus panita, 45 days judicial custody, or 90 days. Yeah, or 90 days in soldier. If the crime is more than 7 years, then what happens? 90 days I don't. Crime on the more than or section on the or commit பண்ணிருக்கிற கிரைம்ல கரெக்ட்டா வந்து 7 years மேல இருக்கக்கூடிய பனிஷ்மென்ட் இருக்கக்கூடிய ஒரு செக்ஷன் ஆட் பண்ணிட்டாங்கன்னா சுமன் பாக்குறாரு 60 டேஸ்க்குள்ள கஸ்டடி ஏன் வைக்கணும், இன்னும் ஒரு 30 நாள் எக்ஸ்ட்ரா வைக்கலாம்னு இவர் நினைக்கிறாரு சுமன். எக்ஸாம்பிள், தி ஆஸ்பிரண்ட் அவர் என்ன நினைக்கிறாரு, அப்பனா என்ன பண்ணுவாங்கன்னா டக்குன்னு வந்து எஃப்ஐஆர் ஆல்டர் பண்ணுவாங்க. ஆல்டர் பண்ணி ஒரு புது செக்ஷன் கொண்டு வருவாங்க. அந்த செக்ஷனோட இன்கிரீடியன்ஸ் இந்த கிரைம்ல இருக்காது சம்டைம்ஸ். அதுல ஆட் பண்றதுனால என்ன ஆகும், கஸ்டடி கிடைக்கும். எத்தனை நாள்? 60 இன்னும் 90 days 90 days வரைக்கும் 90 days முடியும் போது சார்ஜ் ஷீட் போட்டுருவாங்க. You are able to understand? So 15 days, 60 days, 90 days, at the end of the 90th day if the charge sheet is there, then the accused will under investigation la irundhu you will go to under trial. Recently investigation la irukravanga charge sheet போட்டா under trial க்கு மாத்தி விட்டுருவாங்க. prison வேற. I am giving you the practicality. So now இந்த செக்ஷன்ல சேஞ்ச் கொண்டு வரணுமா வேணாமா நீங்க சொல்லுங்க. இப்போதான் ஓல்டு லா நான் உங்களுக்கு எக்ஸ்பிளைன் பண்ணேன். நீங்க என்ன நினைக்கிறீங்க? ஒரு அட்மினிஸ்ட்ரேட்டரா போலீஸ் ஆபீசரா இது மாத்தணுமா அப்படியே இருக்கலாமா? ஏன் சரி ஓகே சுமன் என்ன சொல்றாருன்னா மாத்தணும்ன்றாரு. ஓகே மாத்தணும் சொல்லிட்டாரு. என்ன மாத்தணும்? இப்ப நீங்க தான் லா கொண்டு வரீங்க, புது ஆக்ட கொண்டு வர இன்சார்ஜ் நீங்க தான். என்ன ஆக்ட் என்ன மாத்துவீங்க? அப்ப புது லா விட்டுருவோம் என்ன பண்ணிருக்காங்கன்னு. What has happened in the new law we'll see later. But what will you do as to bring a change? Custody days, he will reduce the custody days. Point number 1. Point number 2, Suman. You have to tell me why also. First you tell me what changes will bring. We will brainstorm. Then we will see what has happened in the new law. Okay? Are you all ready? Are you all ready? Right. Okay. First he says custody days has to be reduced. Overall custody illa police custody? Because you only said that sir judicial custody paravalla, police custody da overall custody குறைக்கணும். Okay, good point. Okay, அப்போ police custody குறைக்கணுமா ஏத்தணுமா? கேஸ்க்கு. Okay, good point. Some more from the girl side. Be open. I said very liberally, don't think about the new law. I am trying to expand your horizon of thinking. Thinking வந்தாதான் புது law நீங்க புரிஞ்சுக்க முடியும். எடுத்த உடனே செக்ஷன் நான் பேசணும் வச்சுக்கோங்க, நிஜமா சொல்றேன், you will hate me forever. இப்ப மட்டும் இல்ல, forever. ரெடி? forever. என்னையா மனுஷன் அப்படின்னு சொல்லிடுவீங்க. சரியா? Come on, you tell me. Whatever is opinion, should we increase the judicial custody or the overall custody or decrease or increase it? Answer. சொல்லுங்க. கரெக்ட். சூப்பர் பாயிண்ட். ஸ்டேட்டுக்கு வந்து ஜெயில் ரன் பண்றது காஸ்டா ரெவென்யூவா? ஸ்டேட்டுக்கு ஜெயில் ரன் பண்றது காஸ்டா ரெவென்யூவா? நீங்க தான் அட்மினிஸ்ட்ரேட்டர். நிறைய பேர் வந்து குற்றம் பண்ணவங்கள பிரிசன்ல வைக்கிறதுங்கிறது ஒரு பாயிண்ட். ஆனா கேஸ் முடியாததுக்கு முன்னாடி அண்டர் ட்ரையல் வைக்கிறது ரெண்டாவது பாயிண்ட். பிகாஸ் ஆஃப் தி லாஃபுல் இஷ்யூஸ்னால, லானால. ஏன்னா சார்ஜ் ஷீட் போட்டாங்கன்னா அண்டர் ட்ரையல் இருக்கிறவங்க வந்து கோர்ட் ரிலீஸ் பண்ண தவிர வேற எந்த ப்ராசஸும் கிடையாது. கரெக்டா? அப்போ அவர் சொல்ற பாயிண்ட் கரெக்ட். அப்போ நீங்க என்ன நினைக்கிறீங்க? அப்போ புது லா என்ன பண்ணணும்? custody period has to reduce. Under trial prisons, நான் அண்டர் ட்ரையலுக்கே வரல, அதுக்கு அப்புறம் வரலாம். அண்டர் ட்ரையல் அப்புறம் வரலாம். நான் சொல்றது கஸ்டடி பீரியட். இப்போ கஸ்டடி 90 days முடிக்கும் போது சார்ஜ் ஷீட் போடலனா மேண்டேட்டரி பெயில். அது தெரியுமா? 90 days முடியுது, ஒருத்தர் கஸ்டடியில் இருக்காரு. 60 days முடியுது, 90 days முடியுது, as the case may be. 90th day அன்னைக்கு FIR ஃபைல் பண்ணி சார்ஜ் ஷீட் போடலனா, if the charge sheet is not filed at the 90th day, I as an advocate for the accused will go to the magistrate or the sessions court, as the case may be, present the mandatory bail. Mandatorily you have to be sent out. So whoever is inside the prison now as an under trial, what has happened was before 90th day or on the 90th day charge sheet was filed. If charge sheet was not filed, then you would have got what? Mandatory bail. அப்போ நீங்க பாத்தீங்கன்னா 20% to 15% of cases only they file charge sheet within that 90 days or at the end of the 90th day. So most of the accused, I will not say criminal, or until the court convicts him, we have no right to say that he is a fraud or a criminal. He is he is accused. There is an allegation on him. That's all I can say, right? So the allegation that he is holding, that is the accused, he will be released mandatorily at the 90th day if the charge sheet is not filed. Now, this charge sheet filing is not done on time. 80% of the cases, the police officials will not file the charge sheet on time. As he said, burdening of cases on the police side. Think about Changalpet, for example. I'm talking about. How much cases will come in a day? Most of the time, people crib saying police doesn't file a complaint. Police case, they are taking cases, but actually, burdening of the criminal justice system. Correct? அந்த எஃப்ஐஆர் போட்ட உடனே அரெஸ்ட் பண்ணணும்னு சொல்வீங்க. அப்ப அரெஸ்ட் பண்ண உடனே திருப்பி எத்தனை கேஸ் ஒரு நாளைக்கு எல்லாத்துக்கும் எஃப்ஐஆர் போட்டா போலீஸ் வந்து எப்படி வந்து mostly police will give time to see whether it matter is amicably finished and he will try to advise. அதெல்லாம் செய்வாங்க போலீஸ். இட்ஸ் a normal thing because எஃப்ஐஆர் ஃபைல் பண்ணாலே எக்ஸ்ட்ரா ஒர்க் ஸ்டார்ட் ஆயிடுது. கரெக்டா இல்லையா? அது ஊர் பக்கத்துல வந்து போலீஸ் ஆஃபீஸரா இருந்தா ரொம்ப கேர்ஃபுல்லா ஒர்க் பண்ணணும். because most of them are family members. Police will give time. அண்ணன் தம்பி அடிச்சுப்பாங்க, வருவாங்க. இந்த எக்ஸாம்பிள் எதுக்காக சொல்றேன்னா, கஸ்டடி டைம் குறைக்கணுமா ஏத்தணுமாங்கிற அந்த டிபேட்டுக்கு தான் நம்ம இருக்கும். ஆனா okay, how many of them, let's get into seeing the numbers. How many of them want that, now that you have understood the custody as a concept, how many of them are for increasing the custody? Please raise your hands. How yeah, ஏன் increase பண்ணனும்? Okay. I'm not talking about the low level of, but those ones the top 10 have done that. Yeah. Okay. Good point. I appreciate it. From that perspective, what he says is custody has to be increased. Now, but many of the people here, okay, how many people don't know whether to be increased or reduced? Why you don't know? Please raise your hands. How many of them don't know whether to increase or decrease? Please raise your hands. Just wanted to know. Why you don't know? There should be some reason why you don't know. You have to stand on either side, either to increase or reduce. But Terla sir means why? Okay, is good. He is not aware of the practicality of both the sides. Good point. Now under the new criminal law, under the Bharatiya, I'm introducing the criminal procedure code, because without saying criminal procedure code, old name, you will not even know which act. Okay, Bharatiya Nagarik Suraksha Sanhita 2023. So shortly we call it as BNSS. BNSS is the new criminal procedure code of India from 1st July 2024. Under that, the fourth issue that we discussed, where they have increased the custody. Mr. Suman, who is an aspirant for IPS, will be more happy to hear that his powers have increased. His powers have increased. For him, the available option today is 40 days and 60 days. 40 days and 60 days. 40 days of the 60 days, 60 days of 90 days. Did you understand? Replacing 15 days. Suman is happy. This is the change. And whose power has increased? Police power. When I say police power, being an administrator, being an IAS aspirant, what has increased? State's power has increased. What has increased? State's power has increased. Now tell me, from 1st July 2024, whether the relationship of the citizen with the state has changed or not. What changed? 15 days is replaced by 40 days. 15 days is replaced by 60 days within 90 days. Then if you have to see that accused earlier after 15 days, where generally people go is Pural in Chennai. If it's other state, respective prison. Now 40 days, where you have to go and meet him? Police station. And he'll be called. And you tell me, I'll tell you honestly, even the 15 days, most of the investigation don't happen. In the 15 days, the police doesn't exhaust 15 days actually. They may need 3 days or 4 days. Already 15 days, the police is not exhausting. Police is not exhausting. They are giving additional custody days for the police. Additional custody days for the police. It's a happy news or a sad news. Until you become police officer, sad news. If you become police officer, happiest news, because you get additional power. Power is what you from morning to evening you enjoy, correct? That power is added now. But courts will keep quiet. Will I keep quiet? Will I keep quiet? If someone is arresting someone, I'm giving an example, okay? I'm giving an example. Someone aspirant, IPS aspirant is arresting someone. Will I keep quiet? I start filing bail. In every bail, he has to give a counter or not in the court. I will file a bail under Bharatiya Nagarik Suraksha Sanhita 2023, New Criminal Procedure Code. And when I file a bail, someone is investigating him in the police custody for a number of days. Can he give the same reply every day? And for me, every time that he rejects, I have an opportunity to go to the same magistrate or the sessions court, as the case may be, or go to the higher court. I can go immediately to the higher court. Higher court is constitutional court. What are the constitutional courts in India? When you are understanding criminal justice system, you should know which is a constitutional court. Which is a constitutional court? Answer is wrong. So, high courts are also constitutional courts. High court is also constitutional court. Supreme Court is also constitutional court. So the answer is wrong if you say Supreme Court is a constitutional court. Let's assume I don't know what is the pattern of your examination in IAS, the UPSC or TNPSC or whatever exams you write. If I am an examiner, probably I'll test this question. Which is a constitutional court in India? Supreme Court or High Court or Supreme Court? Yes or no? Precisely question of law comes from High Court itself. They have the powers to interpret the law. And whatever the High Court comes out of the judgment or the Supreme Court comes out of the judgment, mandatorily, Magistrates and Sessions Court has to follow. Mandatory. That's a law which is binding the magistrate and the Sessions Court. But can Sessions Court answer on the question of law? Answer is no. But they can follow the question of law that is settled by the High Court and the Supreme Court. Now the question here comes, High Court of Madras High Court, does it have a jurisdiction on Hyderabad? How many of them are from Hyderabad? Or from Andhra Pradesh? From other state, sorry. You are from Karnataka. Madras High Court has brought from which part of Karnataka? Shivamogga. Shivamogga, right. Madras High Court has come out with the judgment whether it is applicable to Shivamogga. Why? Karnataka High Court judgment is applicable to Karnataka. Understand the system first so that you understand that. So High Court is a constitutional court, then Supreme Court is the constitutional court. There may be situation of the Madras High Court giving one judgment and Karnataka High Court giving a different judgment. Yes or no? Then that jurisdiction where the Karnataka High Court is prevailing, that judgment will apply. Where this judgment, that is Madras High Court judgment, will be applicable only on the jurisdiction of the Madras High Court. But if there is a question of two high courts, then you have to go eventually to Supreme Court. In Supreme Court also you have larger bench and single bench and divisional bench and constitutional bench. Yes or no? Now under section 19 of the Prevention of Money Laundering Act is questioned in the larger bench of the Supreme Court. Arrest is now questioned recently. So it has been questioned it is referred to the larger bench. That larger bench eventually became constitutional bench. And section 19 of the Prevention of Money Laundering Act, I'm giving an example. Need and necessity has been referred to the larger bench. One word is referred. This is law, my dear friends. Now here, custody. If I am going to the magistrate, Mr. Suman is filing the same one. I am investigating. I got the bank statement. I am investigating. I got this evidence. Every time he submits the same thing, court will grant bail or not? Answer me. Same reply is giving up to High Court. He gives the same reply to magistrate. No progress investigation. He's calling the accused every day under police custody. But he didn't investigate. What reply he will give? Same reply he gives. We are in the process of investigation. Only these evidences we are collected. Then will it not be a ground for granting a bail? Yes or no? Yes. So there is a checkpoint called judiciary on the role of the state. Role of the state. Now you will question me, sir, judiciary and state are the same or not? As per the constitution. You have legislative, executive, judiciary. Is judiciary part of the state? Answer me. Yes or no? Yes, why? Or no, why? Both answers you have to tell me answer. Both questions. It is organs of the constitution. Basic structure of the constitution is the independence of the judiciary. Independence of the judiciary. Who elects the judges of the High Court and the Supreme Court? Is he appointed? Or is it recommended by somebody? Which body? Collegium. Collegium comprises what? Retired, or the system of judiciary only elects the, appoints the judiciary. There is no intervention of the Prime Minister or the Chief Minister. Correct. Whereas in case of the European nations like bicameral democracy of Switzerland, the respective government appoints a judge. That is different rule altogether. In India, the beauty of this democracy is the independence of the judiciary. So the role of the state is transformed under the new law, where the custody is extended from 15 days to 40 days or 15 days to 60 days, as the case may be, has actually increased the power of the state. So this will also go for a constitutional question in the constitutional court. Constitutional question in the constitutional court. Next important issue. We have a break. At 5:30 can be, I think, 1 hour. I don't know what is the rule. Up to 6 I know, but is there a break in between? Okay. Break. Let us get to understand. We have Bharatiya Nagarik Suraksha Sanhita. Next issue. We have special laws. We have special laws. Can you name some special laws? This is general law. Bharatiya Nagarik Suraksha Sanhita 2023 under the criminal justice system is general law. Is there any special criminal laws? POCSO, right? Then UAP, UPA. Okay, then be bold. Answer me, please. Even if you're wrong, no problem, but answer, please. Okay, then think and tell me. You have to answer. Let's interact. You be bold. No right answer, nothing. I will not scold. Don't worry. Whatever knowledge you have, please express. Start expressing. NDPS. Then Narcotic Drugs and Psychotropic Substances Act. Yes or no? That's a special act. Okay. Do you think the special act will deviate from Bharatiya Nagarik Suraksha Sanhita Act 2023? Okay. Let me put this question this way. We are coming to the how many issues we have discussed until now? 4 or 5? 4 issues. Now we are into the 5th issue. There is a general act called Bharatiya Nagarik Suraksha Sanhita. There is a special act called like NDPS Act, Prevention of Money Laundering Act, Prohibition of Benami Properties Act, Prevention of Corruption Act. PC Act, you know or not? Which year it came? 1950. 1988. Prohibition of Benami Properties Act 19. Don't worry if you don't know. I'm not testing you. You need not know at all for information. What trying to bring some consciousness about laws. It is your fundamental duty before you become administrator to know certain laws. Then you will know how to conduct yourself. What are the intricacies of law? Every citizen should know law. That means an administrator who is becoming part of the government should definitely know. Every day you are affected by it. Right? So there is a special act called Prevention of Corruption Act 1988. There is Prohibition of Benami Properties Transaction Act 1988. There is Prevention of Money Laundering Act 2002. Prevention of Money Laundering Act 2002 is a special act. There is a provision, section 19 of the Prevention of Money Laundering Act, special provision on arrest. Bharatiya Nagarik Suraksha Sanhita 2023 also has the provision with respect to arrest. Yes or no? Yes. Which will prevail? Which act has to prevail? PMLA versus Bharatiya Nagarik Suraksha Sanhita, BNSS or PMLA? BNSS. Why? Special act will not prevail. Somebody has committed a crime under PMLA. Somebody has committed a crime under Benami Provision Act. Somebody has committed crime under the Prevention of Corruption Act. Under what act he will be arrested? Answer me first. Special act. Okay, how many of them say as per special act he will be arrested? Please raise your hands. Boldly you answer. You know the answer actually. Every day you see this in papers. Every day somewhere or other you read Hindu paper or Dinamalar, whatever paper, whichever paper you read, you will find somewhere or the other this custody matters coming in, right? Yeah, answer me. Whether special act, under special act he will be arrested or the general act he will be arrested. Special act. What if this general act and special act conflicts? What if this general act and special act conflicts? That is BNS, Bharatiya Nagarik Suraksha Sanhita versus PMLA versus Prevention of Corruption Act 1988. If it is conflict, if it is in conflict, what will prevail? General act will prevail or special act will prevail? Special act will prevail. Maybe you would have answered. How many of them are lawyers here? Law students, for example. Okay. How many of them are law students? Please raise your hand. Law students should raise their hand. You're a law student? Graduation. Okay, no problem. You're a student. You're studying. You're now studying presently? Okay. So, special act will prevail over the general act. Special act will prevail over the general act. Then, is it not the duty of the state to harmonize both the act? Answer is yes. But when it comes to the matter of court procedures, then general act will prevail. Let's assume the special act, okay, there is a conflicting provision, special act will prevail. When there is a special provision, special act will prevail. Arrest is there, arrest is here. Arrest of special act will replace the Bharatiya Nagarik Suraksha Sanhita. It will replace the Bharatiya Nyaya Sanhita 2023 IPC. Crime offense is there in that act, so that offense is taken. That section of that act will be there. Then the procedure either will be Bharatiya Nagarik Suraksha Sanhita, that is Criminal Procedure Code, or special procedure as enunciated under that law will be prevailing. Third question, that special act does not even talk about it. What will prevail? Let's assume the special act does not talk about custody. What will prevail? General act prevail. But that special act will not clarify it. Special act will not clarify it. I'll give a classic example. Now, under the new system of law, this is clarified. This is clarified. I'll give a practical example. What is going on now? In one of the act, what was the problem in that act? It went to the Supreme Court. Now, this kind of situations will not arise under the Bharatiya Nagarik Suraksha Sanhita. Prevention of Money Laundering Act, Section 19 provides for arrest. Section 45 provides for bail. Section 50 provides for summons. What is it? Section 19 of the PMLA Act 2002 provides for arrest. Section 45 of the Prevention of Money Laundering Act provides for bail. Section 50 of the Prevention of Money Laundering Act provides for summons. Arrest is also there in Bharatiya Nagarik Suraksha Sanhita, BNSS. Bail provisions are also there as part of the Bharatiya Nyaya Suraksha Sanhita 2023. Then you have summons provision under the Bharatiya Nagarik Suraksha Sanhita 2023. But as there are special provisions of this kind in Prevention of Money Laundering Act, this will prevail. Under the old Criminal Procedure Code, this was also the same case. But when it comes to the matter of mandatory bail, the PMLA Act 2002 did not say, go and see CRPC. CRPC will never say, go and see PMLA, yes or no. Then matter went to the Supreme Court. Under the PMLA, somebody was arrested. Then when the mandatory bail was applied in the magistrate, that is Sessions Court, because Sessions Court are designated for the purpose of trial of the Prevention of Money Laundering Act 2002. Then the Sessions Court said, I think mandatory bail is not applicable to PMLA cases. Then the matter went to the Supreme Court. Under Vijay Madan Lal Chaudhary versus Union of India, it was clarified that wherever the special act like PMLA is silent about the procedures which are there as part of the Criminal Procedure Code, that means Criminal Procedure Code will apply. Accordingly, mandatory bail is applicable. Now, under the new BNSS, Bharatiya Nagarik Suraksha Sanhita, it is very clear, there is a clear provision to say that if there is a special act and there is a BNSS, which is a general act, then mandatory provisions which are absent there will get inserted automatically, unless that special act says that this provision of BNSS is not applicable. This provision of BNSS is not applicable. Let's assume in the Prevention of Money Laundering Act, I'm just giving an example. If certain provisions of the BNSS is not applicable, then the Prevention of Money Laundering Act itself should say this is not applicable. If it says that way, then as a lawyers, what we will do? We will check whether it is because Criminal Procedure Code straight away affects the Constitution. Yes or no? Then what we will do? We will go and do a checkpoint. Whether it is affecting the personal liberty, whether it is affecting the fundamental rights of the citizen. Then we will go and hit and see whether constitutional provisions are affected. Then we will question in the court through writ petition, Article 226 of the Constitution of India, plus or through Article 32 of the Constitution, directly to the Supreme Court. I hope you understood fundamentally how things are going to be transformed in the days to come. So, Special Act, General Act, there is a provision of the Special Act, then the Special Act will prevail over the General Act. And second element of the Special Act, if the Special Act specifically says refers Bharatiya Nyaya Suraksha Sanhita, then you will refer the BNSS. If the Special Act doesn't talk about BNSS, then you'll go through the writ petitions, rounds of writ petitions, to check whether it is applicable or not. Let me come to the next phase of discussion. Issue number 6. We have a break. We have been seeing about issues of the system of criminal justice system of the new law with the different aspects of the legal system. Now, can we appreciate about the new law? This man seems to be against the new law is what you would have understood. Now, I'm going to appreciate. Don't say that I'm a supporter of the new law now. Shortly in another 5 minutes. Under the new law, punishment has been transformed. Under the new law, punishment has been transformed. Okay. Before we discuss about what are the kinds of punishment that we need to give, let us try to understand. If you are a legislator, let us suddenly shortly become elected representative. Suddenly you become elected representative. You are in the parliament. I am the speaker. You are all the elected representative. We are going to bring this new law. We are going to debate. There is a ruling party which is trying to bring this new law. You are part of the opposition party. There is a set of people who are opposition party. You want to transform the face of punishment. Broadly, how do you want the punishment to be transformed? Please answer one by one. Don't tell me you don't know. Because whenever issue happens in the society, we only talk, he has to be hanged in the public. Yes or no? Yes or no? Some issue happens in society. இதெல்லாம் விடக்கூடாது கண்டிப்பா அவர் விடக்கூடாதுன்னு சொல்றோமா இல்லையா அந்த மாதிரி you tell me now you are sitting in the parliament, I am the speaker, there are opposition party, there are ruling party, you are a legislator, you are taking up the role of the legislator, you are going to bring this act. Mind you, whatever you are going to propose is going to pass in both houses of the parliament. This is an opportunity for you. Tell me what punishments you will bring. Classify the offense and tell me the punishment. Don't tell me you don't know. You all know. Open up. Come on. Otherwise, I will have to pick and check you people. Don't tell me you don't know. You all had that kind of a courage to at least share with your parents. இந்த மாதிரி ஆளெல்லாம் என்ன பண்ணணும் ரோட்ல வச்சு அப்படி சொல்றீங்களா மாட்டீங்களா திட்டுவீங்களா மாட்டீங்களா அடிக்கணும் அதை பண்ணணும் இதை பண்ணணும் சொல்வீங்களா மாட்டீங்களா பனிஷ்மெண்ட் கொடுக்கணும் உடனே அவங்களை வந்து அரெஸ்ட் பண்ணணும் சொல்வீங்களா மாட்டீங்களா அப்படி just brainstorm and tell me what is the punishment that can be brainstormed under the new law. New law has not come is what you should think. What are the punishments you will brainstorm? Answer. Being a law student, you start. Avoiding death penalty, capital punishments. Okay, good point. That is their perspective. Somebody may say, bring death penalty for certain crimes. That is their perspective. Okay, how many of them say death penalty is important? Don't think about, don't worry about, leave all the thing. Death punishment சில விஷயத்துக்கு தேவை சார் இல்லாமலாம் இருக்கக்கூடாது. Please raise your hand boldly. Okay, right. 2. How many of them say life imprisonment is important to be important punishment in the Bharatiya Nyaya Sanhita 2023? I'm getting into Bharatiya Nyaya because criminal procedure code is what? Bharatiya Nagarik Suraksha Sanhita. Bharatiya Nyaya Sanhita 2023. நியாயம் கிடைக்கணும் இல்லையா அந்த நியாயம் வந்து டெத் பெனல்ட்டியா இம்ப்ரிசன்மெண்ட் ஃபார் லைஃபா இம்ப்ரிசன்மெண்ட் ஃபார் 7 இயர்ஸா லைஃப் டைம் இம்ப்ரிசன்மெண்ட் இருக்கணுமா இருக்கக்கூடாதா ஓகே தென் third brainstorm and tell me, come on, you all know the answer, all knowledge is within you, please answer. See, I'm putting a lot of energy to bring inquisitiveness in you. 4 punishments சொல்லிட்டு போயிடலாம். Section 4 of the Bharatiya Nyaya Sanhita 2023. 4 punishments இருக்குங்க அப்படின்னு சொல்லிட்டு போயிடலாம். But I'm trying to bring that kind of a inquisitiveness to think and answer. Yeah, come on. என்ன ஃபர்ஸ்ட் வந்து டெத் லைஃப் இம்ப்ரிசன்மென்ட். வேற என்ன வெரைட்டி ஆஃப் பனிஷ்மெண்ட் கொடுக்கலாம்? இந்த ஒரு படம் வரும்ல அன்னியன், அந்த மாதிரி திங்க் பண்ணுங்க. டிஃபரெண்ட் பனிஷ்மெண்ட். டெத் பெனல்டி ஓகே, லைஃப் இம்ப்ரிசன்மெண்ட். அடுத்தது சொல்லுங்க. கம்யூனிட்டி ஒர்க் சூப்பர். ஏன் அது கொண்டு வரணும்னு நினைக்கிறீங்க? அது ஒரு பனிஷ்மெண்டா? Super point. Please clap hands. It's a good point. Yes, thought through. But in the புது ஆக்ட்ல இருக்கிறது பாத்தீங்களா எங்கயாவது? ஓகே, பார்க்காம சொல்லியிருக்காருன்னா நல்ல லெஜிஸ்லேட்டர் அவர். எப்படி இந்த விஷயம் ஒன்று இருக்குன்னு பார்க்காம அவர் சொல்லியிருக்காருன்னா நல்ல லெஜிஸ்லேட்டர். In the sense, he has thought through that. Community service is not actually a punishment. எல்லாரும் பண்ணணும். ஓகேவா? அந்த கம்யூனிட்டி சர்வீஸ இப்போ ஒரு பனிஷ்மெண்டா கொண்டு வந்திருக்காங்க. பாரதிய நியாய சன்னிதா 2023ல. டெத் பெனல்ட்டி இருக்கு. யாரெல்லாம் டெத் பெனல்டி சப்போர்ட் பண்ணீங்களோ டெத் பெனல்ட்டியும் இருக்கு பாரதிய நியாய சன்னிதா 2023ல. லைஃப் இம்ப்ரிசன்மெண்ட் சில அஃபென்சஸ்க்கு இருக்கு. மூணாவது, கிரேவ் ஹீனியஸ் அஃபென்சஸ், ஆர்கனைஸ்ட் கிரைம்ஸ் வந்து டிஃபைன் பண்ணிருக்காங்க புது ஆக்ட்ல. அண்ட் ஃபிஃப்த் இம்பார்ட்டன்ட் திங், த பனிஷ்மெண்ட்ஸ் ஹஸ் இன்க்ரீஸ்ட் for the crime against women and children. a much needed reform in the country. Much needed reform in the country. There are separate chapters under the new Bharatiya Nyaya Sanhita 2023. We'll see that in detail in tomorrow's session. But in today's session, I'm trying to bring the broad picture of what has undergone a change in Bharatiya Nyaya. First, I spoke about Bharatiya Nagarik Suraksha Sanhita, trying to interplay with different legal aspects. Now I'm trying to bridge that with the new Bharatiya Nyaya Sanhita 2023. Then I'll move to Bharatiya Sakshya Sanhita Abhiniyam. Abhiniyam 2. Adhiniyam. So that 2023. So that's only Evidence Act. So crime, procedure, evidence. So Bharatiya Nyaya Sanhita 2023 la punishments, there is an innovation, or rather a nice thought that has been brought by the government on the punishment aspect. And as he said, community service has been brought as an important punishment. Let's assume somebody is an alcohol, he consumes alcohol every day, overdosed alcohol. And the drunken drive case. Okay, our punishment okay, imprisonment or fine, whatever. The most important, what could be the great punishment that can be given to him? Think and tell me, under the act. And the mari drunken drive case ke enna or best punishment. Imprisonment பண்றது, custody எடுக்கிறது இதெல்லாம் ஓகே, அதெல்லாம் ஒரு ஆஸ்பெக்ட் ஆஃப் தி கிரிமினல் ஜஸ்டிஸ் சிஸ்டம். அவருக்கு ஒரு ஆர்டர் போடுறது, என்ன ஆர்டர்? Go and serve in the rehabilitation center. Correcta இல்லையா? Is it not a good idea? This was not recognized under the criminal justice system in the past, but this has found a place in the new criminal justice system, Bharatiya Nyaya Sanhita 2023. This is a very, very important reform which is going to transform the space of judiciary. I just somewhere remotely, I was interacting with one monk of Ramakrishna Mission, where he told me in some Calcutta High Court judgment, where husband and wife were fighting continuously. They keep on filing petition by petition. Then Calcutta High Court, being a constitutional court, has a right to pronounce. They have a constitutional court where they indicated, please go to Jairam Padi, where Sharada Amma was born, and spend 15 days there serving people, so that you can understand what is the relevance of community service. That is where I heard about it, but now it has found a place in the Bharatiya Nyaya Sanhita 2023. So community service is a very important, it is not a punishment, it is a transformation that criminal justice system is trying to offer as an opportunity. As an opportunity. So there are multiple other changes which are brought under the new criminal justice system. Let me come to the next point of appreciation of the new criminal justice system. Of course, there may be views against it or supporting it. The word sedition is not part of the new criminal law, Bharatiya Nyaya Sanhita 2023. Under the new Bharatiya, that is IPC, that is Bharatiya Nyaya Sanhita 2023, what we can find, act affecting the unity and integrity of India is being brought as a definition. Speaking against the government is not seen as a serious crime now, but speaking against the nation is seen as a serious crime. There's a difference. Speaking against the government, speaking against the nation. Speaking against the government, speaking against the nation. Do you find a difference in it? Give me some classic examples. Ruling government, a political party getting elected, forming the government, trying to legislate the issues of the people, as an act. Every day, a legislature has to do that only. Apart from interacting with the public, conducting rallies, and going and speaking to the people about their political ideology, getting translated to the legislature is the basic idea of any political party. The promise of the Tamil Nadu political parties were social justice. They delivered it. They have to further re-engineer it in the future. Further re-engineer it. Social justice is the base of Tamil Nadu. Nowhere in the world you find 69% reservation for as an affirmative action. Nowhere in the world through the legislature. 69% as an affirmative action. You may be supporting it, you may not support it. That's different. Personally, some may be affected, that may be beneficial to somebody. That is different. As a social fabric, as a nation's fabric, this system is which is very unique in the state of Tamil Nadu. Now, coming back to the unity and integrity of India, speaking against the government is not seen that serious as compared to, or is not seen as a issue compared to speaking against the nation. That is the first transformation with respect to nation as a consideration in the new law. In the new law, so when the government says they have tried to remove the colonial, whenever the government which has brought this law speaks to the public, what they say, they have tried to remove the colonial. They have not tried to remove. You cannot remove the British law from India, whether like it or not. Okay, because we are all based. What did I say? The source of law in India is common law jurisdiction brought by the Britishers. The common law is only spread in Europe. Common law only is spread in all the colonies, whether it is Uganda ruled by the Britishers, whether India ruled by the Britishers, whether Sri Lanka ruled by the Britishers or the Europeans. It is a common law jurisdiction which is prevailing. Which is prevailing in India. And this common law jurisdiction, what you have adopted as a language, is based on lexicons, like terminologies from Europe. So all this terminology, legal terminologies are from Europe. Now when you say we have replaced colonial system in India, meaning it can never be done, but one thing is speaking against the nation is one thing that has transformed from the perspective of colonial baggage. That has to be appreciated, because we should not be against nation at any point of time. The binding force of opportunity for us is nation. Binding force as an opportunity for us is nation. Binding force of integrity is nation. Binding force of unity is nation. Anything which affects the unity and integrity of India is seen as a serious crime under the new Bharatiya Nyaya Sanhita 2023. And who will be most affected in it, you tell me? In this section of who will be getting affected? Who will be basically violating? Okay, that is okay. Insurgents, okay. People who want to divide the country. Then, people who give political speeches will be affected primarily. Somewhere, most of the time, they will not speak against the government. Certain times they will go limitless and speak against the nation. So, considering it, this section has come as a checkpoint for people who are violating, to speak about affecting integrity, unity, and unity of India. That is nation. Then the next point of appreciation of the new law is defining what is an organized crime. This is the last part of discussion, and then we'll have question answer session. Tomorrow I'll come with specific certain sections and then explain. With that, you'll understand the overall. Tomorrow's session is very important. You inform your friends also, because tomorrow's session I'm trying to brainstorm with the team, and then trying to bring what could be some of the questions in the competitive examinations. So that could essentially be one of the questions. See, Article 348 could be one of the questions. Yes, that is fundamental to the Indian Constitution. The beauty of the competitive examination, as I understand from Shankar IAS Academy, because I have not written any IAS exams. I don't know how government exams are conducted. All that I know is subject I'm trying to deliver here. Here, when I come here, they clearly told me every mark is important for you people. I am very conscious about it. Tomorrow, I'm going to deliver all the sections which could be a different questions that can be the lookout of the examinations. But today, I'm just trying to expand your horizon so that you think in that direction. And you yourself should think what are the questions that could be possible by looking at the papers. Last point of appreciation of the Bharatiya Nyaya Sanhita 2023 is organized crime. My dear friends, the entire world is against organized crime. If you go and check the Vienna Convention, you all must be aware of Vienna Convention. If you're not aware, please go and check tonight. All the new terms which I'm speaking is more relevant for the administrators, and whether this question comes in the examination or not, you should have there are some essential knowledge which you should carry. People, from the perspective of people who are preparing, when you take a newspaper, you should understand each and every term. When you start understanding each and every term, that means you're going to be successful. FATF, Vienna Convention, is a very important convention where the entire world was against organized crime. The organized crime like drug trafficking, child trafficking, human trafficking, it is organized, it's not random. Can you imagine? There is a system created behind organized crime. This organized crime was not defined in the old act. Why? Because when the old IPC Act came, this organized crime was not integrated across the world. Were never even thought through. But over a period of time, organized crimes have increased. Drug trafficking, child trafficking, human trafficking, arms trafficking, all these are all organized crime. Beyond that, locally also there are organized crimes. Crimes that happen. So the police department or the law enforcement departments are aware of these organized crimes. They keep on, if you see in the railway stations, ஒரு 10 பேர் படம் போட்டு be aware of the பார்த்திருப்பீங்க. They are identified. Anything that happens in that locality, immediately they are called. அவங்களுக்குள்ள நெட்வொர்க் இருக்கலாம், அவங்க வந்து சொல்லலாம், they can become give a witness, அந்த மாதிரின்னு ஒரு சிஸ்டம் இருக்கு. அதுக்குன்னு ஆர்கனைஸ்ட் கிரைமுக்குன்னு ஐ டோன்ட் நோ தி ஓவரால் ஆஸ்பிரண்ட் ஆஃப் ஐபிஎஸ் ஆஃபீஸர்ஸ் ஹியர், அதுக்குன்னு ஒரு டிபார்ட்மெண்ட் பார்த்துக்கிட்டே இருக்காங்க. அது தெரியுமா? So who is aspiring to become IPS officer, please go and check how the department functions. It's all available in the public. Organized crimes வந்து லோக்கல் ஏரியால எப்படி இருக்குன்னு ஒரு இன்டெலிஜென்ஸ் இருக்கு. யாரை டார்கெட் பண்றாங்க, என்ன பண்றாங்கன்னு செக் பண்றதுக்கே அவங்கள வார்னும் பண்ணுவாங்க. யாரை வந்து விக்டிம் ஆக வாய்ப்பு இருக்கோ அவங்கள வார்னும் பண்ணுவாங்க. அதுக்கு ஒரு சிஸ்டம் இருக்கு. அதுதான் செக்யூரிட்டி அவங்களே கொடுப்பாங்க சம்டைம்ஸ். So இது why is the system evolved? Because we are countering the organized crime. It's a very, very important role the police officials play in every state. When I say every state, every country. It's a challenge to the police official. Daily basis la idu counter பண்றது தான் பெரிய சேலஞ்சே. Random crimes வந்து ஈஸி, அதை ஹேண்டில் பண்ணிக்கலாம், அது வந்து என்ஃபோர்ஸ்மெண்ட்ல கொண்டு வந்துருக்கலாம். அந்த ஆர்கனைஸ்ட் கிரைமை பிரேக் பண்ணி சரி பண்றது தான் ஒரு கவர்மெண்ட்டுக்குமே ஒரு பெரிய சேலஞ்ச். இந்த ஆர்கனைஸ்ட் கிரைமை ஃபர்ஸ்ட் டைம் பாரதிய நியாய சன்ஹிதா 2023 they have defined what is an organized crime. This organized crime is the basis for money laundering. This organized crime is the basis for narcotics act. This organized crime is basis for child trafficking. So all these organized crimes are now defined to bring the offenders under the law. Much appreciated under the new law. Much appreciated under the new law. We'll see the sections tomorrow, but I have given a broad things from different perspectives. What could be the lookout of the examiners? Broad aspects. But getting into the detail, I will do it tomorrow. I'm going to discuss only from these 7 perspectives tomorrow. In specific, today I spoke about the issue. Tomorrow I'm going to speak about the solution. This understanding is more than sufficient to crack first the understanding on law, 2 to prepare for questions that could come in the examination, and cracking that with the right answer. Three things are important or not? I understand, I read, but I'm not able to crack na pocha illaya. So, appo moonume important. Understanding of the law, 2, getting into the detailing of the law, 3, writing the right answer in the examination. Final நீங்க முடிச்சு அந்த ஃபைனல் ரைட் ஆன்சர் எழுதுனாதான் இதோட பெனிஃபிட். கரெக்டா? ஓவரால் அண்டர்ஸ்டாண்டிங் இருக்கிறதுக்கு, பப்ளிக் சர்வீஸ்க்கு, ஃபியூச்சருக்கு ஓகே. அல்டிமேட்டா கரெக்டான ஆன்சர் எழுதலனா என்ன யூஸ் இருக்குன்னு நினைக்கிறீங்க உங்க எஃபர்ட்டுக்கு? ஸோ எக்ஸாமினேஷன் பெர்ஸ்பெக்டிவ்ல இந்த 2 ஸ்டெப் நீங்க இந்த லாஸ் பொறுத்த வரைக்கும் பண்ணணும். Definitely I'm going to brainstorm. I have added some more questions in my preparations where what will be the lookout of the examiner. I'm going to give the summary tomorrow. What will be the lookout of the examiner in the country on any competitive examination, whether it is TNPSC or UPSC or banking or whatever. Banking law லையும் criminal procedure இருக்கு. Banking law லையும் banker இருக்காரு, bank manager இருக்காரு, அவர் violate பண்ணிடுறாரு. எந்த ஆக்ட் கீழ அவர் கொண்டு வரணும்? First யார் cognizance, who has to take the cognizance of the offense? Reserve Bank of India has to take as per 58E of the act. Then that means that will override police officer. Yes or no? So like this, each position that you are looking out has an impact in the criminal procedure code. Let's assume you are an IAS officer appointed as the chairman of the public sector undertaking. Possible or not possible? State run public sector undertakings are there. You become an IAS officer. You are appointed as the MD and chairman of it by the government. There is a violation of company law. Whether Bharatiya Nagarik Suraksha Sanhita will be applicable, or Companies Act section 447 will be applicable. Fraud related section of section 447 will be applicable. Companies Act. But the procedure which are not mentioned as part of the company law, where there is a reference to the criminal procedure code, Bharatiya Nagarik Suraksha Sanhita will be applicable. So expand your horizon of understanding. Don't try to narrow down only to the police official. There is a company fraud that happens. Then there is a separate agency in India called Serious Fraud Investigating Officer under the Companies Act. They sit here in Chennai in company law, in the corporate Bhavan. Regional offices there in the corporate Bhavan. They are law enforcement agency for the company law, for the matters relating to serious fraud investigation. This got strengthened from 2013. This comes under section 209, 210 and 211 of the Companies Act 2013. This is a investigation process whether Bharatiya Nagarik Suraksha Sanhita 2023 will be applicable or not. Answer is yes, it will be applicable. But the special provision of the Companies Act will prevail over Bharatiya Nagarik Suraksha Sanhita. But what are the other procedure? Custody procedure, arrest procedure. If it is not there, then it will be applicable here. Like this interplay of different administration departments has to be understood by all of you. My lookout from you people, you please understand these 3 laws, new criminal laws affecting the administrators, because you are aiming to be one. From that perspective only, they will be questioning in the examination, is my understanding. Let's assume you are an IAS officer. Can you be arrested immediately as per new criminal law? Is the next question that I'm going to answer tomorrow. Let's assume one of the person is IAS officer. There is a Prevention of Corruption Act charge on him. Whether he can be arrested immediately, or is there any procedure, special procedure provided under the Bharatiya Nagarik Suraksha Sanhita 2023? Whether prosecution sanction has to be obtained. If prosecution sanction is not obtained, whether that arrest is valid or not. These are all some of the things that essentially you should know. Maybe these are all the lookout in the days to come. If I am an examiner, I will think what way I can test this law based on the examination that you are appearing, UPSC or TNPSC, how it is affecting the administrator. Right? So these are, if you have any question, please ask me those questions, or if you want me to cover specific areas of applicability which you feel has to be covered, let me know, I'll cover it. I'm for you and I'm here for empowering you. Nothing I'm going to carry from here. Because I practice in the court and my clients come and meet me. Clients do not know this. If they know this, it's more headache for us. because they'll start buying the law books and start reading and start questioning and then start interpreting, and then because they're in the problem, yes or no? I appreciate that from the client, but I'll be more happy if the student is of that same caliber. Think that if you're in a problem, how will you think on a subject? Did you understand? Even when you are reading, get into the roles of the respective subject. Then when you get into the roles of the respective subject, I try to bring the roles like parliament, you are a lawmaker, think and tell me yes or no. Then you go to the understanding of the law, then it will be easy for you. Okay, let me take some questions from all of you. Any questions? Yes. I think any party which is coming to power, they're very clear in mandate. The party which is not clear in mandate can never come to sustained power. This government, since the time they brought the mandate, you can go and check the electoral that is election mandates, which they have been publishing since 30 to 40 years. You take, download and see all this they have mentioned. Whether like it or not, that is different. I may be with a different view of this present government. I may be support of the present government. That is different. They have sustained UCC. They sustained Uniform Civil Code. They sustained abrogation of Article 370. They sustained construction of the temple. So like that, each and everything, they have been very clear in their mandate. So this is reforming a law is one of the mandate they carry. Now that the majority of the people have voted them, they are carrying through each step. There is no agenda behind them other than the election mandate. The election mandate itself is an agenda only. So considering it, you have to understand what they have said in the election mandate only they are carrying. I may agree or disagree. Let's broadly look at the issue. I may be supportive, I may not be supportive. Even while explaining the law, I'm not supporting of everything. Neither you should be. Otherwise, progress of knowledge will not happen. You accept certain things, neither science progress can happen or your knowledge progress can never happen. You should uncondition and then look at the issues. That's my thing. So they are very clear what is the next step to be done. So UCC has been delayed for various reasons, but reforming a criminal justice system, bringing a provision where when somebody speaks against the nation was part of their agenda, always. And they brought it. So there is no special reason that they have done. And they deferred this effectiveness from 1st July. Why they did not bring before 1st July? Definitely elections are a reason. Then that should not become a point of debate. It should not affect them also in different states. So understand the perspective how political economy functions. Then you get the answer as an administrator. Your answer is question is a valid question. Social justice is part and parcel of Tamil Nadu's any party. Now let's assume a question where you want to reform the social justice further to enhance it. What will you do in Tamil Nadu? There are many answers. Internal reservation for the government school children, for various exams, for the government school students. Ensuring that all the government officials' kids should study in the government school. For the reforms. How to improve the quality of education of the government school? If you're an administrator, I'm putting on this question. There are many reforms you can provide. Yes or no? So it's a never-ending process. When one policy starts and that becomes the agenda of the people, we have to keep improving it. The legislator has no role other than that. So here you can never be against social justice and become a legislator. So it is a broad understanding, Usha. Is it good for the country? Broadly, yes. But are you affected? Maybe I may also be affected. That's different. But how do you bring reforms for the people is the question of policy. So this new criminal law has many plus and minus. I broadly covered which will be applicable to you. Tomorrow, I will cover from this each section wise and deliver you what will be useful for your examination. So today is just to bring up understanding. Tomorrow is to bring up questions and deliberation. Tomorrow, maybe it will be boring, but it will be useful. Today, it is very interesting, but this is only an understanding. So that's the point. So we'll get into the detailing tomorrow. And thank you so much for this opportunity to Shankar IAS Academy. And thanks to Vaishnavi ma'am who invited me for this session. I'm sure this was useful to all of you, not just as a preparation perspective, but definitely from the perspective of as a citizen of this country. If you don't understand, who else will understand this? That should be the driving factor behind understanding this. And my Instagram is there. You can see all those these things I keep adding up every day to the public, and millions of people actually appreciate this kind of things. And I'm very happy to bring this to your knowledge, so that to keep getting the knowledge required for, as a citizen, to enhance yourself and be confident in this country. There is a system to take care of. Thank you for this wonderful opportunity. Thank you.